Dr. Randy Cooper here on behalf of plaintiffs.
Good morning.
Your Honor, Travis Gagne on behalf of defendants, Eric and Paula Cassidy.
All right, very good. All right, this is actually the time and date for your motion, I do believe, isn't it?
The judge was ready to keep the case until she learned another lawsuit had already been filed in circuit court.
The motion for this court to assume jurisdiction.
Yes, Your Honor.
All right, yes, go ahead.
Yes, Your Honor. On behalf of plaintiffs, we are requesting that the court accept or ask for concurrent jurisdiction. So from the circuit court, so the matter can be kept here in district court, where Your Honor has had a lengthy experience and history with the case, and we feel it would be just most efficient from a judicial perspective and from the party's perspective if the case could continue in front of Your Honor. In the alternative, we would request if the court is unwilling or unable to get concurrent jurisdiction, that the case be permitted to be moved to circuit court because the claims exceed the court's district jurisdictional limits. The defendants filed a response, a very brief response, indicating that they did not oppose the relief, the primary relief requested or the alternative requested.
A routine motion, or so it seemed, walks into court. Then a surprise filing changes everything and forces the judge's hand. What follows is a courtroom pivot no one fully expected.
Thank you, Your Honor. I'll start by saying I appreciate the extra time that you gave us at the last hearing for me to catch up on the case and to file our response, put it on the record. Ms. Cooper is right. We have filed a response on behalf of the Cassidys. There is no opposition to either requesting concurrent jurisdiction from the circuit court or asking that it be removed up the circuit court for the monetary claims here. The only thing that I will say, again, and I think that's everyone is in agreement, the only thing that I will say is that I think that request needs to be made of the circuit court in the last 2 weeks. We are now on our 5th docket. So a new case has been filed in circuit court. It is now before Judge Tracy Vandenberg. It is filed on behalf of Cambridge Family Holdings only. The Jeromes are not plaintiffs or any party to the case. His name again is Eric and Paula Cassidy. It is the same claims that are before Your Honor. And I know that because there's still a 14A1 district court case caption on the complaint.
So
I need finality is what I'm saying. And so
hold on. A new case got filed in circuit court?
Yes.
I
missed Hope.
Yeah, I figured as much. All right. So that means that there are 2 cases pending in circuit now?
There are now 2 pending cases in circuit court.
The 2 in circuit court, are they before different judges?
They're both before Judge Vandenberg.
Okay. All right. So let me shortcut this a moment. Because one of the things is, and it used to be, and I'll just try to be as nice about it as I can. It used to be, for the sake of judicial efficiency, that those judges in the district court would be able to take cases, they'd get the assignment, it'd just be pretty much rudimentary. What has come up in a couple of cases, so some do go through, some don't, is that there isn't a concurrent plan that would allow this court to take it, which is very odd. And because normally what would happen is I would just be appointed a circuit court judge and just deal with it. Personally, and as a judge, I don't have any objection to doing that. I don't think that process would work. I don't think that it's beneficial. And again, this is my personal feelings. I don't think that it's beneficial for the parties. I think counsel is right. I've been dealing with this case, I don't know how long, and I don't know how far Judge Vandenberg has gotten into it. I mean, I'm sure she'll catch herself up and do what is necessary, but it seems to me that you're going to be spinning your wheels there trying to just catch up. I will say also, now knowing what you've told me about another case being filed, that doesn't surprise me. And Miss Tope is not here, is she?
She's not here.
It gonna be, I'm too old to worry about getting myself in trouble.
You're only 29.
Okay, so maybe I am. There is another case not involving these parties, which had the same issues regarding Miss Tope's involvement. That I basically had to, I don't want to say force her, but she had to withdraw from that case. So I would suspect that Miss Tope did that because Miss Tope may not want to see me. Just be blunt about that, but that's okay. I get that. So that indeed does not surprise me at all. So I think in ruling on this motion, I think what's going to happen is it's going to have to be moved up to Judge Vandenberg for her to hear this case. If Judge Vandenberg in some way wants to send it back, and I want to make this very clear, I have no objection whatsoever to the issues coming back before me. None whatsoever on it. And so, and if she believes that we could go through a process of maintaining, let this court rule on it, her certifying this court's rulings, however she may see that type of procedure, if it could work, I don't have a problem. And so that's how I'm going to rule on this, that the case needs to be removed. She does have the power to send it back to me if she believes that that's the case. Sorry. I'm going to miss you guys. All right. Okay. Anything else before that removal becomes final that I need to deal with?
No, I think.
Your Honor, can we have 1 minute?
Sure, absolutely. I'm sure I'm probably surprising you. And can I just say one other thing? And I don't know what you guys are talking about, but and not only if Judge Vandenberg wants to send it back, but if there are portions of this that, because of where we are in this case, that Judge Vandenberg does not have a problem with this court ruling and wants to do that, I am not going to have any objection to that, because I think not.
What looked like a routine jurisdiction motion turned into a full court transfer after a surprise filing came to light.
I think it's a waste of time and effort from that the parties have put into the case to have to do it this way. So, go ahead.
Sure. We just had a quick sidebar. We would like to request. We know where you are coming down on this. We would like to request you to put another conference maybe on the calendar in 2 weeks and hold this under advisement before making a ruling, to allow the parties who are here in the courtroom today to further discuss before this gets removed from your courtroom.
Okay. You agree with that?
Sense to you?
Yes, Your Honor. We would request that the decision be held in abeyance for now, and then we reconvene in 2 weeks.
Do I have 2 weeks?
You have the 10th and the 17th.
10th or the 17th, whichever. You know what? Is that February 17th?
Yes.
You're not going to want to be here that day.
Why?
I think there's going to be a lot of press around here.
On the 10th, you said?
On the 17th.
Yeah, I'm free today.
Okay. So
Yeah.
I will adjourn this for a decision to February 10th, 2026, 9 a.m.
I'm sorry, what time?
At 9 a.m.
Thank you.
Thank you, Your Honor.
All right, thank you, folks. And again, my apologies on all of that. And could council approach briefly?
Your Honor, Dominic Hanson, here on behalf of the plaintiff.
Ashton Kapelski Legal Services, and Billy Pyatch and Chase Pyatch are present as well, Your Honor.
Okay, but you're not representing them. Is that correct? Pardon? You only, because she's a student. I get it. Which is a weird thing that you guys need to change that. I'm just saying.
So, Your Honor, we've discussed this case at a couple of mediation sessions. We've also discussed it down the hall. We're continuing to have some settlement discussions, counsel and I. There's still some paperwork we want to exchange. But I think what I would ask the court to do is maybe set this for a trial date. It's been pending for some time, maybe for March. I do have 2 trials set in February already. I am playing well with others. I do want you to know that. It's just cases that aren't reaching finality like they're supposed to be, or what I'd like them to be. So what I was hoping is we could maybe set this for a trial date, and counsel and I would continue to talk between now and then.
Your Honor, I would agree, we're continuing discussions to try to settle. March is too early, in my opinion. I would like to have some formal discovery as well, including possibly a deposition. I'm hoping that we could do a trial date near the end of May.
End of May?
If there's, may I approach?
Yes, May. All right. Record to reflect, we've had a bench conference in this case. What I'm going to do is I'm not going to allow any other additional discovery. Counsel, the way this court operates, they're to cooperate with each other, but I'm not going to allow depositions at this point. I will entertain that request at a later date necessary. With regard to dates on this case, I will set a final settlement conference on this for March 3rd, 2026 at 9 a.m. I'll set a non-jury trial date for March 25th, 2026 at 9 a.m. Okay.
All right, thank you, Your Honor.
I think that was everything, Counsel. Thank you, folks.
One new filing flipped the courtroom strategy in seconds. Jurisdiction isn't just procedure. It decides who controls the fight. In court, timing and filings can be as powerful as the arguments themselves.